right, time. Let's talk about those two cases, okay? I had two consultations with people in removal proceedings. They're wondering on whether or not USCIS has jurisdiction over the case. The first person, the green card was actually denied. But the second person, the green card is still pending. The application is still pending with USCIS. Let's start with client number one. Now, client number one gets here in the US in the late 80s with a visa, according to him, then married a US citizen. However, the marriage ended in divorce, okay? The divorce, so the green card was denied. And when the green card was denied, the person was ordered removed in 2009. So now the person has a child who turned 21, and the child petitioned for the client's number one. Okay, I'm calling person client, but client's number one for the purpose of this conversation. So the child petitioned for the client, and the I-130 is approved, of course, because, you know, it's the child of the client number one. However, the green card is denied based on lack of jurisdiction. The person comes to me for a second opinion because their lawyer is filing the form EOR 27 with BIA to argue on jurisdiction, that USCIS has jurisdiction. Well, this is the caveat on this case. This person got here, okay, with a visa. Later on was ordered removed in 2009. I'm not sure when, because they didn't disclose to me when they traveled outside of the country, okay? After they were ordered removed or prior to being ordered removed. Let's go with scenario one. If they travel outside of the country prior to being removed, and then they came back on parole because they asked for advance parole when the green card was pending. That's why they were able to travel outside of the United States, because they didn't have any valid visa. So then they got inspected and paroled back to the United States. They are not an arriving alien for the purpose of jurisdiction with USCIS. So that person, client number one, well, cannot adjust status with USCIS because he's not an arriving alien. Does not meet any exception because guess what? They have been ordered removed. They travel outside of the country prior to removal, and then the person was paroled back. So inspected, paroled back. They are not a arriving alien for the purpose of adjusting status with USCIS. So they have to, first of all, join motion with ICE, terminate removal, and be able to adjust status once the case is dismissed. That's really the best way to go about it. But now the person claims that no, because they travel outside of the United States, that's scenario number two, right? They travel outside of the United States after being order removed, meaning that they have executed that order of removal. Therefore, they meet the one of the exception to adjust status with USCIS, because now USCIS, the court does not have jurisdiction over the case anymore. But guess what? USCIS still denied the case because USCIS still claimed that they lack jurisdiction over that case. Why? Because now USCIS is arguing that because the person left, they executed their order of removal, now they are barred, post-departure bar. That's why they cannot adjust status with USCIS. And of course, even if a lot of court or circuit, they have struck down that post-departure bar, that person is still required, okay, to reopen their old removal case terminate, removal, or dismiss the case so that they can be able to adjust status with USCIS. The fact that the lawyer filed EOR 27, I mean, it's an argument, right? But guess what? If EOIR 27, meaning that the case is going to BIA, the appeal is going to BIA, first of all, it's going to take forever, right? Almost 4 years, 5 years in order to get a response on that appeal. And guess what? The appeal is still going to be denied because they are going to claim post-departure bar. Everybody's going to say we don't have jurisdiction over the case. So the best way to go is just to, terminate removal proceedings and adjust status with USCIS. It's really that simple in terms of if you have been ordered removed. If you don't meet the exceptions or the exceptions not really clear to you, right now the Dolly memo is available and ICE is most likely to join motion. If you have I-130 approved, no criminal record, you are not a priority, they will definitively join that motion. And you can easily reopen case, terminate removal proceeding, or dismiss the removal proceedings so that you can adjust status with USCIS instead of going through all that and ended up with a denial again at the BIA level, not to mention how long it's going to take for BIA to give you that response of jurisdiction. Easiest way is to join ICE, really to reopen your case, because right now they will do it because of that memorandum, the Doyle memo is still valid. This is election year, it's still valid at least until November because we don't know who's going to take power, right? But that's the best way to go about this case. So the second person in almost the same scenario, different slightly, been ordered removed, filed I-130 and 485 concurrently with USCIS. They never left the country. They came with a B1 visa, visitor visa. I told them, you're just wasting your time. I-130 might get approved, but the green card will not get approved. Even though you went to the biometric, to the interview, the green card will not get approved because of jurisdictions. Later on, it's going to be denied. Why? Because you've been ordered removed, you never departed, you came with a visa, you are not an arriving alien, you don't meet any exception. And in your case, if there's fraud and misrepresentation, you will not be able to adjust status either, because in order to waive fraud and misrepresentation, you have to have a qualifying relative for the purpose of adjusting status and for the purpose of waiving fraud and misrepresentation. So conclusion is this, right? If a person is in removal, best way to go about it is to just try to join ICE, terminate, dismiss removal based on I-130 being approved, and adjust status with USCIS. And this is the moment to do it. Why? Because the climate is favorable. If you're not a priority, you can go and watch my other videos on who's priority, who's not priority based on the Doyle memo. If you're not a threat to border security, you didn't come here by the border, stuff like that, cross illegally, stuff like that, ICE, you don't have criminal record, ICE will definitively join that motion to reopen and terminate if you have I-130 approved and prima facie eligible to adjust status. Those are the two cases with my two potential clients. I told them, guess what? Now that the first one has already been denied, don't waste your time with BIA. Just try to reopen this case. That's it. The other one, they're still waiting for the response. But I told them, it's still going to be denied because of lack of jurisdiction. You don't have any argument about jurisdiction. So if you need a consultation with me, because those people came for second opinion, really, after they've done things on their own, but still they got some type of clarity, right? If you need a second opinion or you need to reopen your case, this is the time to do it. You can schedule your consultation by using the link in the description box below. Until next time, bye-bye.